Early on, there'll be conversations about what the case is about, and there's usually early posturing in these cases as to the merits or the lack of merits of the case. Then you'll wind up either answering the complaint if you're a defendant, which is a formal document, or waiting for an answer, and then the case will essentially move into the stage that's known as discovery. It gets put on the court's calendar. So you have to request it to put it on the court's calendar. The court will give you a certain amount of time to do discovery. And discovery is basically where I'm going to find out all the information I can about your case, and you're going to find out all the information you can about mine. And you do it through exchanging documents and taking depositions, which are basically where you're sitting in a room and the other lawyer gets to ask you questions under oath. It's recorded by a court stenographer, and you use those tools to help either build your case or defeat the other person's case. Unfortunate thing about discovery is it's extremely expensive, and it's the area of probably the greatest abuse in litigation. In the old days, before they changed the rules, there was no discovery in civil cases. You would just basically go in, you file your complaint, you'd have a couple pretrial conferences, you go in and put your witnesses on. Nowadays, discovery kind of takes on a life of its own, and you have whole classes of lawyers litigators who don't try cases.
What does that mean?
What they do is
discovery?
They just do discovery. That they don't do discovery, and it's kind of a shame in some ways, because until you've actually had to prove something or disprove something to either a judge or a jury, you don't really realize, you don't get to know how important the discovery is or isn't, and you can wind up just doing it for the sake of doing it. There's quite a few litigators who don't try cases. They just do discovery.
So I don't get it. So they do discovery, and then what do they advise the client after discovery?
Sometimes they do. Sometimes they hand them off to other lawyers who try cases.
Okay. So then they subspecialize.
Yeah, I mean, that's a kind word for it, in my view. I mean, I think that if you're going to hold yourself out as a litigator, you should be able to take the case from point A to point Z and be done with it.
Right.
If you can, but there are lots of lawyers who are just not wired for standing up and arguing and arguing cases and putting cases in to a judge or to a jury in evidentiary form. It's a very different skill. Now, people who come from the criminal background tend to be more comfortable doing that, because criminal cases, there's less discovery. There's very little discovery in criminal cases. There's some, and you're trying cases. I mean, those cases are many more criminal cases get tried than civil cases on a percentage basis, because those are the types of cases that ultimately go to.
I'm going to ask you a personal question.
Sure.
How do you feel about this word, confrontation?
I think it's an unfair word.
Okay,
I mean,
what does that
listen,
mean?
to some degree, this business is a confrontational one. There's no doubt about it.
That's why I'm asking you.
However, in my view, to be effective, you need to take the confrontation out of it. First off, the lawyers should never be confrontational. It's not their fight.
With each other, right. It's
not, I mean, and when you personalize it, not that you don't, and when I say personalize, not that you don't care about what happens to your client, but when you personalize
emotion
with your adversary, you're doing your client a disservice. Because what it's going to want to do is taking on a dispute of its own, a life of its own, and a dispute within a dispute, and all that does is cost the client money. And so, I mean, am I comfortable with confrontation? Obviously, I don't mind it. Otherwise, I would find something else to do for a living.
Right.
Do I like the adversarial nature of it? Yeah. I mean, it fits my personality. I've always liked it. And people say I'm argumentative. I don't think so.
Are you a scrapper?
I was a scrapper. Yeah.
Okay. Okay.
And it's the kind of thing that you either take to it or you don't. Now, you can do it in different ways. You can be aggressive. Doesn't mean being, as a litigator, doesn't mean necessarily fighting over every single little point. You can be a very aggressive litigator if you take aggressive positions, but those positions should be substantive. They should be. They shouldn't be tangential to what the ultimate claim is. You got to keep your eye on the ball. If you don't keep your eye on the ball, all you're doing is your client a disservice.